Afternoon. We're back on the record. It appears that a non-unanimous stipulation and agreement was filed by Evergy West, the Commission staff, and the Office of the Public Counsel. It looks like, at least on one page, it indicates that the Midwest Energy Consumers Group and Velvet Tech Services do not oppose this stipulation. What about Nucor?
Nucor does not object to the stipulation.
Thank you for letting me know that. Before we go into openings, I've got one quick question about the stipulation that maybe somebody can answer for me. I haven't had an opportunity to do much more than skim it. But in looking at provision 9 regarding the financing order, it states the signatories agree to utilize the company's filed financing order with updates and other adjustments necessary to comply with the statute 393.1700 RISMO and incorporate the stipulation and resolution of contested cost recovery issues. In regard to that, how binding do you see that being on the commission? I mean, are you wanting basically to have the order, the order that was filed along with not filed, that was attached to Mr. Lundy's testimony issued as it is with minor changes? Or is this one where, because the commission is already doing, I guess there were some questions about format compliance and whether or not this format will work with the way the commission does its reports and orders for a financing order. In other words, would it be sufficient if the commission kept the substance of the order but perhaps put it in a different format? Can anybody answer that for me?
I think we were anticipating that the format that we filed in Mr. Lund's testimony would be used, but there are some changes that will need to happen to that.
I was going to say, Judge, from staff's perspective, format wasn't really honestly something that we were looking at so much as substance of the document. And I agree with Mr. Steiner. I think there are changes that will need to be discussed between the parties, frankly, to come up. I was anticipating some sort of compliant financing order being submitted.
I think that's right. Yeah, it's not going to look. There'd be changes from the version that's in Mr. Lund's testimony. So it'll have to be submitted to the commission. And
is it your intent for the commission to then take that wholesale? Because I know that the commission is probably want to, at least as to issues that aren't resolved, do its own findings of fact, conclusions of law and such that one would normally see in a report and order.
Yeah, I don't think there'd be a problem with that as to the issues that are not resolved.
Okay.
But like Mr. Steiner said, I mean, we're going to have to, we the parties, not we including you, but the parties are going to have to submit something, I think, which incorporates, as the stipulation says, the statute and the stipulation, because there are some.
I guess to just cut to the chase of my question, is it going to be a deal breaker if the commission does its own order that incorporates the substance of Evergy West's submitted order?
It's hard for me to answer that without knowing what that is.
And I get that, and I do, but nonetheless, I need to ask it because we've got one of these already in the works, and certainly there were some questions about whether the format of the one that was attached to Mr. Lundy's testimony was satisfactory for not just the statute, but for the commission and 536, among other things.
I'm just not familiar with the formatting order, formatting issue that the commission might have. If the
And having just skimmed it, I wish I could be more specific, but I can't at this time.
I understand.
Why don't we do this, then? I think I've got as much of an answer as I'm going to get at this point. Why don't we go through what issues, and like I said, I've skimmed this, what issues does this resolve on the issues list? Let's just go through that real quick.
So one, I believe it does resolve between staff and company, but there are additional OPC issues that will need to be tried.
Okay. So what subletters under one still remain? Because when I skimmed it, I
So-
think I saw something in regards to prudence issues, but also something in regard to carrying costs.
So I think 1G remains.
Okay,
That would be 1H as well.
okay,
1I remains. 1J remains. 1K remains.
at least in part.
Yep. I think that's it, but other,
Okay, what about anything in regard to 2, 3?
hang on just a second.
Okay.
Sorry. 1M remains. I don't think 2 remains. I don't believe so. I don't believe that's an issue anymore.
Okay,
I said, what about A and B?
3, let's see. Three A would remain. Issue 4 would remain. Issue 5 would remain. Issue 8 would remain. Sorry, issue 8 does not remain.
and 6 and 7 do not?
I don't believe so.
Okay, thank you very much, Mr. Steiner, I appreciate that. I think myself and others would like to look the stipulation over. I certainly applaud the effort everybody's put in. What I think I'd like to do at this point, before we excuse any witnesses from those issues, is maybe, since I've only got their court reporter till 4 today, is why don't we try and get through openings? And if we get through openings, maybe end the day at that point and take up tomorrow morning the issue of which witnesses we're going to keep and which ones will be excused.
We did go through all that. I can give you the recommendations of the witnesses that parties don't believe they have questions for.
That would be great, Mr. Steiner, thank you. Go
So,
ahead.
Jason Humphrey, we do not believe any party has questions. John Bridson, no questions. Matt Gummig, no questions. John Carlson, no questions. Jay Lubert, no questions. Mark Davis, no questions. John Robinette, no questions. That's it that we were able to, at this point, come to an agreement on. So, if the commission has questions, we'll make them available.
Okay, and like I said, why don't we address that tomorrow morning? And that'll give me a chance to take a look at it tonight and see if, I know at least for some of those, the commission had some questions, and see whether they still want to follow through with those.
Yeah, Judge, if I could jump in here real quick. Mr. Steiner indicated that no other party had questions for Mr. Davis of Ducera Partners, who is staff's outside consultant. There might or may not be some issue. The sooner I can know whether he needs to come in from New York, the better, I guess, is where I'm going with this, Judge. So if the commission has questions, we can certainly make him available, and otherwise we may not. Thank you.
Okay, and it looks like even if we were to get rolling tomorrow with the list we have, it appears that we probably wouldn't get to Mr. Davis at that point anyway, perhaps. But I will try and,
Oh, yeah, he won't be here tomorrow. I'm sorry if I misled you there. He's scheduled to be here on Thursday, so I don't know that he could be here before Thursday.
okay, well then I've got a little bit of time to figure this out. Thank you. Okay, I'm going to follow the order of openings that was proposed by the parties. And with that in mind, let's start with Evergy, Missouri West.
Thank you, Judge, and may it please the Commission, Carl Zobrist from the Denton's Law Firm in Kansas City. And just for the record, I think we've had the rest of council introduced, so I won't do that in the interest of time. Because of the filing of the non-unanimous stipulation agreement within the last hour, I've tried to trim down my opening statement, so I'm not going to, for example, regale the Commission about the devastation that was wrought by Winter Storm Uri. Everyone has accepted the fact that that was an extraordinary event. It was an anomalous weather event, and it does qualify as an extraordinary cause under the statute. So no party has disputed that, and I'm going to proceed to talk about some of the dollars issues. Our testimony reflects that that staff and the company and some of the other parties did differ in terms of the qualified extraordinary costs. The non-unanimous stipulation that was filed has a figure in there of $278.5 million, and that is the amount that we believe qualify as the storm costs from Winter Storm Uri for purposes of the stipulation. Now, before the enactment of the securitization law, there were only two ways that an electric utility could recover these costs, or two customary ways. That was to rely upon the standard fuel adjustment clause mechanism under Section 386-266, the Commission's fuel adjustment clause rule, with deferral to a regulatory asset under the plant and service accounting statute, or to seek an accounting authority order under the general powers of the Commission to defer these expenses into a regulatory asset and then seek recovery in a subsequent general rate case. Those customary solutions would have imposed substantial financial burdens upon Evergy's customers as well as the company. However, the securitization law now offers an innovative and cost-saving way to address these difficult issues through securitized utility tariff bonds. And Evergy's Vice President of Regulatory Affairs, Darren Ives, is present and can answer any questions that the Commission may have with regard to him or the other parties. Now, what can be securitized with these bonds? There are two categories, only one of which is relevant to this proceeding. The first is the financing of qualified extraordinary costs that were incurred prudently during anomalous weather events. And then there's another section under the statute that deals with energy transition costs. Now, the recent Empire District Electric Liberty case dealt with both categories. This case is less complicated. We're only dealing with the qualified extraordinary costs. Those costs are defined as those of an extraordinary nature, which would cause extreme customer rate impacts if they were reflected in retail customer rates and recovered through customary rate making. A cost qualifies if it was incurred prudently during anomalous weather events. And John Bridson, Vice President of Generation for Evergy, is here to testify as to the prudence of costs incurred by the company during Winter Storm Uri. We believe that as a result of the discussions that have resulted in the non-unanimous stipulation and agreement, that the costs of Winter Storm Uri fuel and purchase power are $278.5 million. And we calculate the carrying costs, again, as a result of the discussions between staff and the company, to be $20.9 million. And I'll deal with how we came to that figure a little bit later. But what I want to stress is the focus of this proceeding should be the period of time when Winter Storm Uri costs were incurred. The securitization statute, we believe, does not call for a wide-ranging inquiry into events that occurred prior to February 2021. It does not permit a review of the company's past decisions that were made regarding issues like resource planning, corporate strategy, or other issues. The securitization statute provides for the recovery of financing costs, both what we call upfront costs and ongoing costs. And we have stipulated that the estimated upfront costs are $6.6 million. Again, this is the stipulation with staff. Now, the statute requires that there be a net present value showing. It requires Evergy to show that issuing the bonds and imposing the securitized utility tariff charges necessary to recover the extraordinary costs and the associated financing costs are expected to provide quantifiable net present value to retail customers compared with the customary method of financing, and that's right out of the statute. Evergy must show that. The Commission must find that the charge is expected to provide quantifiable net present value benefits to customers as compared with the customary method of recovery. The evidence in this proceeding will show that even in today's rising interest rate environment, that the expected benefit to Evergy's customers is, we believe, approximately $45 million at a minimum and possibly as high as $100 million. Ron Clote, Senior Director of Regulatory Affairs and a CPA, will present this net present value benefit analysis to the Commission. Now, why is this apparent? Why can these net benefits occur? They can occur because the securitization bonds themselves are secured by an irrevocable right to bill, collect, and receive charges that are subject to periodic adjustment. And the irrevocable right is defined in law as the securitized utility tariff property. And this is the property that Evergy will seek to sell and will be purchased by its wholly owned bankruptcy remote special purpose entity. The SPE will issue the bonds and will transfer the net proceeds from their sale to Evergy. And it's important to remember that the securitized costs in these bonds will never contain an equity component and will never include any cost of equity. And Evergy's Assistant Treasurer, Jason Humphrey, is here to discuss this in response to any questions from the Commission. Page 18 of our petition contains the transaction. I know the Commission is generally familiar with that from the Liberty case, so I won't go into that in any detail. There is a process by which a financing order would be issued by the Commission if it approves the petition. And it deals with a number of requirements. I believe there are 15. And it's very prescriptive, and it tells the Commission that if it grants the petition, it must include findings and orders with regard to those 15 elements. Similarly, after the financing order is issued, Evergy is required to present you with an issuance advice letter prior to the issuance of the bonds. Your financing order is to include the form of the issuance advice letter to Evergy that will indicate what the final structure of the bonds is, a best estimate of the total ongoing financing costs, and the initial securitized tariff charges. And the issuance advice letter will also certify that the securitization of the qualified extraordinary costs and the financing costs will provide quantifiable net present value benefits to customers. And it will also detail the role of the staff and its advisors and how it will work with the company in that process. I presented the Commission with a list of our direct testimony witnesses, and I really present that more as a playbill for anything else so everybody can see who exactly is here in Jefferson City and who is going to testify to what. We have 5 witnesses from Mr. Ives and Mr. Clote to a number of others, including Mr. Lundy from Citigroup, who provided direct testimony. A number of them also provided surrebuttal testimony, but we have other witnesses that addressed specific issues that were raised in rebuttal, and that's set forth there in that PowerPoint. No party opposes Evergy's petition for securitization, and no party opposes the request to securitize some measure of Winter Storm Uri costs and the associated financing costs. There are disagreement on the total costs. I'm not going to go through the stipulation in detail, except to say that among the issues that have been resolved were imposing the 95%, 5% split or sharing mechanism. Evergy initially opposed that, and we think there are good reasons for that, but in order to come to a negotiated settlement with regard to the entire proceeding, we have come to a figure that resolves that issue as far as we are concerned. There are some issues concerning upfront financing costs, I believe, from perhaps the position of public counsel, but I'm not going to speak to them. The non-fuel operating and maintenance cost issue has been resolved. Public counsel has reserved the right to deal with the imprudence issue, and I want to speak to that for just a minute. Lena Mandel, Ms. Mandel, is the leading witness for public counsel, and I simply want to talk about a couple of the points that she makes. In our view, she goes beyond the scope that is required by the statute to look at what actually happened during Winter Storm Uri. She has lengthy testimony that goes back before Evergy Missouri West, before KCP&L, Greater Missouri Operations Company, going back to Aquila, criticizing the integrated resource planning efforts of the company. We don't even believe that's relevant. And to the extent we get in this, I will probably object simply to preserve that legal objection on the record, but we don't believe that that is relevant to this proceeding. The other thing that I would point out is that one of the things that is shocking to us that Ms. Mandel recommended is that Evergy Missouri West should have turned off its customers' electricity during Winter Storm Uri in what she delicately calls a controlled service interruption to conserve resources. And we can't imagine what would have been the public reaction to that. The headline in the Kansas City Star would have probably read something like, Evergy cuts off power to customers to save money. We don't believe that that recommendation is consistent with the statutory obligation upon an electric utility in Missouri to provide efficient and safe service on just and reasonable rates as embodied in section 393.130.1. There are some tax issues that Public Counsel has raised. They were raised by Mr. John Riley, and Evergy's Senior Director of Taxes, Melissa Hardesty, provides rebuttal to them. There are also some disputes over with Public Counsel on carrying costs and the discount rate. Mr. Murray is Public Counsel's witness on that, and we have responded to that, I believe, in Mr. Ives' testimony and Mr. Klote's testimony. We do have agreement on the affiliate transactions rule. Staff, in rebuttal, Ms. Boland, I believe, stated that they did not oppose the waiver of Section 2A, which is the standards section in the affiliate transaction rule, and the company agrees with that. That's fine. There are a variety of tariff and billing issues and cost allocation issues, and I understand that there may be some questions from the commissioners on that, and Mr. Lutz and I believe Mr. Gummig are here to respond to those issues. Let me just close with an observation about the rising interest rates that I mentioned earlier. As we all know, the Federal Reserve raised the interest rates by 0.75%, 75 basis points last Wednesday, July 27. There were some other economic reports that came out later in the week, kind of a mixed bag, but not all bad news. It appears that although the data from June itself shows that inflation was proceeding at a rapid rate, it has already declined, and here we are now on August 1st, and it appears that the natural gas prices and gasoline prices and some other commodity and food prices have declined. And the important thing to remember is that regardless of what we are dealing with right here today, at the time of the issuance advice letter, it has to certify that the financing of the qualified extraordinary costs and the financing costs will provide those net present value of benefits. And that's what should give the Commission assurance that issuing the financing order and issuing and granting the petition and the other provisions that the financing order contains will be in the public interest and will save customers net present value benefits for many years. Thank you, Your Honor.
Thank you. Any questions from the Commission? I hear none. I've got a couple of short, quick questions. And if these are better answered by a witness, please let me know. One of the things that I know is concerned is what does Evergy see as the level of staff's representatives' involvement?
We think the statute is very clear, and I know that Mr. Ives talks about this, but they have the right to provide input. There is a collaborative process, but the actual legal right and the statutory right to place the bonds is with the utility and with its financing advisors. And unless Mr. Steiner has anything to add, I would say that Mr. Ives would be the person to elaborate this with.
And secondly, as you had mentioned in your opening, the Fed has now, in very short succession, raised rates twice to attempt to rein in inflation. And I'm assuming with each time it does this, it diminishes or affects that net present value. Does Evergy West at this point, if there were to be another interest rate hike, does Evergy still see this as a feasible solution?
I will defer that ultimate question to Mr. Lundy from Citigroup, who is here, because he can talk about the interest rates. But the only thing that I would just say as their counsel is that those rates affect both debt and equity. But Mr. Lundy is the best person to respond to that, and perhaps Mr. Ives.
Okay, thank you. Next opening statement from the staff of the commission.
Judge, if I might beg your forbearance a little bit here, if I could do my opening from the seated position rather than standing at the podium due to my leg issues, I would appreciate it.
That's absolutely fine. Go ahead.
Thank you, sir. May it please the commission, I'm Jeff Keevil, representing staff of the commission. As you are aware, this case involves the request of Evergy Missouri West for a financing order authorizing the issuance of securitized utility tariff bonds pursuant to section 393.1700 RSMO. This is a relatively new statute, and I believe this is only the second hearing the commission has had under the statute. Now, I originally wrote this opening prior to the filing of the stipulation and agreement, so I'm going to kind of on the fly here try to delete portions of it and move things along as well as I can. As the case was originally filed prior to the stipulation, you were going to be asked to, and you still are, frankly, but asked to decide some issues that I would consider to be in the nature of traditional utility rate-making issues, like, disallowances and adjustments and things of that nature. Several of those have been resolved as a result of the stipulation, at least as between staff, company, and to some extent public counsel. However, the statute 393.1700 contains several provisions which I would not consider to be traditional, and I'm sure Your Honor is aware of them, at least not traditional in Missouri, and requires the commission to make a rather lengthy list of findings in the order itself regarding several of these matters. And the statute also provides for certain processes or procedures which are not typically encountered in Missouri. One of the several items that the commission is required to find in the order is that the proposed structuring and pricing of the securitized utility tariff bonds are reasonably expected to result in the lowest securitized utility tariff charges consistent with market conditions at the time the securitized utility tariff bonds are priced and the terms of the financing order. Staff's outside consultant, Mark Davis of Ducera Partners, LLC, in his rebuttal testimony, discusses the importance of the involvement of staff's designated representative and advisor throughout the process, including the bond structuring, marketing, and pricing process. He will be available to testify later this week, and encourage you to ask him any questions you may have regarding the staff representative and advisor process as he has seen it employed in other jurisdictions that have securitized utility tariff bond procedures. So what is a designated staff representative? That's a good question. It's one of those non-traditional rate-making items that I mentioned earlier. The statute provides in part that as the actual structure and pricing of the securitized utility tariff bonds will be unknown at the time the financing order is issued, prior to the issuance of each series of bonds, an issuance advice letter shall be provided to the commission by the electrical corporation following the determination of the final terms of such series of bonds, no later than 1 day after the pricing of the securitized utility tariff bonds. The commission shall have the authority to designate a staff representative or representatives from commission staff who may be advised by a financial advisor or advisors contracted with the commission to provide input to the electrical corporation and collaborate with the electrical corporation in all facets of the process undertaken by the electrical corporation to place the securitized utility tariff bonds to market. So the commission's representative or representative can provide the commission with an opinion on the reasonableness of the pricing terms and conditions of the bonds on an expedited basis. Now you'll notice that the statute, and I believe Mr. Zobrist also referred to the issuance advice letter. The statute provides that the issuance advice letter shall be provided to the commission by the corporation, in this case Evergy West, no later than 1 day after the pricing of the securitized utility tariff bonds. Statute goes on to say that unless an earlier date is specified in the financing order, the electrical corporation may proceed with the issuance of the bonds unless prior to noon on the fourth business day after the commission receives the issuance advice letter, the commission issues a disapproval letter directing that the bonds as proposed shall not be issued and the basis for that disapproval. One little side item here that I would mention, you should be aware that the draft financing order submitted by Evergy Missouri West, which you referred to earlier, Judge, attached to the direct testimony of Evergy's witness Lundy, actually shortens the time in which the commission may issue a disapproval letter from noon on the fourth business day after the commission receives the issuance advice letter to noon on the fourth business day after pricing of the securitized utility tariff bonds. And as we mentioned earlier, I believe, on the record, that financing order is going to require the parties to, if you look at the stipulation, I believe there's language in the stipulation about the signatories to the stipulation agree to utilize the company's order with updates and other adjustments necessary to comply with the statute and to incorporate the stipulation and the resolution of contested cost recovery issues. That, what I just mentioned there, that shortening of the disapproval process time would be one of the areas that I would expect to be addressed in the, by the parties when they address the financing order. Hopefully here now you can see that the importance of the financing order itself, and I'm sure you're aware of it prior to me saying anything. On July, well, excuse me, I'll just skip that. As I mentioned earlier, there are a lot of issues that you must decide under the statute, and I'm not going to address every single one of them in this opening. However, I would like to touch on one area that I'll refer to as the rate design and tariff provisions, which are primarily included in the list of issues as exhibits 4 and, as issues 4 and 5. If you look at staff's statement of position on issue 4, you will see the first sentence of staff's statement of position states that the commission order should state the Winter Storm Uri SUTC should be recovered from all applicable customers on the basis of loss-adjusted energy sales. Then if you look at Evergy Missouri West statement of position on the same issue, you will see that the first sentence of Evergy's position statement says, Evergy Missouri West concurs in staff witness Lange's recommendation to use loss-adjusted energy sales to allocate the SUTC among the company's customers. In other words, Evergy has changed its position from its direct testimony and come over to staff's position in their surrebuttal, and effectively, from my perspective or my interpretation, has effectively abandoned the position that it took in its direct testimony on that issue. Now, staff will present or make available at least 5 witnesses in this proceeding. We have Jay Lubert, Brad Fortson, Mark Davis of Ducera Partners, which is staff's outside consultant on this case, Kim Boland, and Sarah Lange. If you have any questions on their issues, I would encourage you to ask them, as I'm sure they can give a much better answer than I could. But one thing I would like to point out here is you were asking, excuse me, Mr. Zobrist was referring earlier to the designated representative, and there is a provision in the stipulation in which I cannot find at the moment since I need it, but there is a provision in the stipulation that addresses the involvement of the staff's representative in the process, which at least the signatories to the stipulation have agreed to. And like I said, I can't find it right now, but would just want to mention that. It's very important from staff's perspective, the involvement of the representative and advisors. And so I don't want that to be overlooked. With that, I will be quiet, and like I said, we will have witnesses available throughout the week if the commission has questions. Thank you.
Thank you, Mr. Keevil. Any questions from commissioners?
No questions, Judge.
Okay, I have no questions at this time. Moving on, opening statement from Midwest Energy Consumers Group. Commissioner Kolkmeyer, was that you who said you did not have any questions?
Holzman.
This is Commissioner Kochmeyer, and I have no questions either.
Okay.
I believe that was Commissioner Holzman.
Thank you very much. We were just trying to sort that out. Go ahead.
May it please the Commission, my name is Tim Opitz on behalf of the Midwest Energy Consumers Group. And the single issue with the largest impact on commercial and industrial customers is issue 4. How should the securitized utility tariff charge be allocated? Now, if we look at as an example, just the large power class of customers, using the staff's loss-adjusted energy sales per kilowatt hour, which I'll refer to as their FAC method, compared to what the company had proposed in its direct testimony, the large power class customers would pay a rate that's approximately 46% higher than it otherwise would. This would be true for customers in that class who curtailed during the storm and didn't use power, and it would be true for customers who were not even in existence during the storm for the life of this securitized charge. The FAC method does not allocate charges among the retail customer classes. It inappropriately shifts costs to commercial and industrial customers, and it should be rejected. Instead, any securitized cost you approve should be allocated among retail customer classes using the method as proposed in the company's direct testimony of Bradley Lutz. What he did in that testimony was customer class revenue allocations adopted by the Commission in Evergy's most recent general rate proceeding. And this method is consistent with the provisions of the securitization statute discussing allocation among retail customer classes and updates incorporating changes from general rate proceedings. Specifically in his direct, in the direct testimony of Mr. Lutz, the company allocated total first-year revenue requirements to each of the company's rate classes based on class revenues set at the conclusion of ER 2018-0156, which was the company's last general rate proceeding. Then the company used the energy billing determinants from that case to calculate the per kilowatt hour charge for each class, dividing total class securitization revenue requirement for each customer rate class by the kilowatt-hour sales for each customer rate class. As you've heard, in rebuttal testimony, the company has acquiesced to the staff's proposal to treat the securitized charge as if it were a fuel adjustment charge. And as I mentioned earlier, the Commission should reject this approach. This is not an FAC case, it is a securitization case. The language of the securitization statute talks about the allocation of cost and subsequent adjustments in the context of how those allocations should be done in a general rate proceeding. Only the approach presented by the company's direct testimony satisfies that requirement. MECG supports the approval of the securitized utility tariff bonds only to the extent that there are quantifiable net present value benefits of securitizing those costs. Whatever amount you, the Commission, authorize in this case, the Commission should order the company to follow the statute and develop rates for each customer class using the methodology from its direct testimony. Thank you for your attention, and I'm happy to answer any questions.
Thank you. Any commissioner questions? I hear none. I'm going to ask you,
Sure.
kind of just to be sure I understand this. Now, my understanding is MECG wants to allocate the securitized utility tariff charge on the basis of class,
That's correct.
which I believe from submitted testimony you indicate complies with the language that's used, that the statute itself uses the term class. Is that correct?
The statute itself, I'll say it's section 393.1700.2, section 3CH, uses the term, or the sentence says, how securitized utility tariff charges will be allocated among retail customer classes.
Okay. I think one of the concerns that I remember fairly early on in this is that we're talking about if there are these securitized bonds with a life of 15 or 17 years, that it may outpace some of the rate cases, or some of the rate cases may outpace it. I may be speaking. In other words, that classes could change in a rate case, and that could present a problem with how the allocations are done. And and at least that was my understanding as to why staff was recommending that it be done on the basis of usage. Am I misunderstanding that?
So I don't want to speak for staff's concerns. I know they had multiple concerns in the testimony of Ms. Lange. But I will say that that same provision of the statute that I just quoted to you does talk about updating it within the context of a general rate proceeding, the allocation. So it's true that that could change within a rate case. Does that answer your question?
It does. Thank you. I have no further questions.
Thank you, Judge.
Opening statement from Nucor Steel.
Mr. Chairman, Commissioners, Judge, my name is Mark Ellinger, Ellinger & Associates, on behalf of Nucor Steel Sedalia LLC. As you may recall, Nucor takes service under a special contract that this commission approved in 2019. In 2021, Section 393-1700 was passed by the General Assembly, and that's the statute that created this securitization proceeding that we're under today to address extraordinary costs that are caused by an extraordinary storm. That statute expressly excludes applying any securitized utility tariff charge to any customer taking service under a special contract that existed as of August 28, 2021. Nucor is taking service under a special contract that was entered into prior to August 28, 2021, and therefore pursuant to Section 393-1700.1 sub 16 and 393-1700.2 sub 3 sub C sub D, no securitized utility tariff charge should be imposed upon Nucor under the statute. Happy to answer any questions. Thank you.
Any questions from commissioners? I have no questions at this time either.
Thank you very much.
Opening statement from Velvet Tech Services.
Mr. Chairman, Commissioners, Judge, my name is Stephanie Bell, and I am here on behalf of Velvet Tech Services, LLC. As you are aware, Velvet plans to construct an $800 million enterprise data center in the Kansas City metro area. The project is a result of numerous partnerships at the local, state, and regional level. Velvet supports MECG's position on Issue 4 as to allocation. Costs should be allocated among customer classes consistent with the requirement in the securitization statute and consistent with the direct testimony of Mr. Lutz. Staff's method, what Mr. Opitz called the FAC method, puts the burden of securitization disproportionately on Evergy's largest customers, potentially disincentivizing large customers from locating in Missouri, and is contrary to the way this commission has traditionally and consistently approached and facilitated economic development. While the securitization statute does state the charge is non-bypassable, the statute must be read in harmony with Missouri's other statutes which are designed to attract large customers to Missouri. The securitization statute cannot be read or implemented without also recognizing the public policy of this state in attracting large-scale projects to our state. On behalf of Velvet, I respectfully request that this commission adopt MECG's position as to allocation, or issue number 4, in this matter. Thank you.
Thank you. Any questions from commissioners? Okay, I have one that I probably could have asked Mr. Opitz as well, but you unfortunately get to answer it. You said the FAC method, and that the FAC method, if you're supporting MECG's position, is inappropriate. Why would the FAC method be inappropriate, since that would normally be how these costs would be recovered through the FAC?
I think if we compare the direct testimony of Mr. Lutz as to which classes were causing the costs, and we go back to traditional rate-making principles of cost causation, for some of the same reasons that Mr. Opitz said, when you compare the cost based on causation, what was in Mr. Lutz's direct testimony, with the revised costs that are in Mr. Lutz's surrebuttal, consistent with staff's FAC method, we're getting away from cost causation principles, and it disproportionately affects customers who are utilizing large amounts of energy.
Do you believe the FAC scratch that? I have no further questions.
Thank you.
Your Honor, other parties may object, but I would make myself available for additional questions. You kind of mentioned you had wanted to ask me about that, but and I'm willing to do so if you're so inclined.
If you'd like to go ahead and answer that, I would love to hear the answer. You don't have to come up if you don't want to. You can do it from your seat.
I believe the question you posed to Ms. Bell was whether, if it would be collected through the FAC otherwise. And I think the answer from MECG's perspective is that these sort of costs would not be collected through the FAC. As the company's counsel mentioned in opening, these extraordinary costs would either be deferred into a regulatory asset, or they would possibly be deferred into a accounting authority order. So that would be my response. Thank you.
Okay, so the only reason it wouldn't be recovered through the FAC is because you believe it would most likely, given the size of it, be moved into an AAO or something else similar.
I think that that's the direct response. I think Ms. Bell's answer also addresses the cost causation impacts of it, which if it were taken into an AAO would be hashed out in the context of a general rate proceeding.
Okay, thank you, MECG. Okay, final opening statement today from the Office of the Public Counsel.
Thank you, Your Honor. I wanted to let you know that Ms. Mantle is handing out copies of the handouts I'll be going through today, so I'll wait just till everyone has that to get started. Good morning, and may it please the good afternoon now, and may it please the Commission. My name is Lindsay Van Gerpen, and I'm here today on behalf of the Office of the Public Counsel. Today, I want to focus on fairness. What is fair for Evergy Missouri West to recover for the Storm Uri costs that it incurred? The OPC is not here today to oppose securitization, nor do we dispute that Storm Uri was an extraordinary event. We recognize that the frigid conditions caused Evergy Missouri West to incur increased cost. We also know that as a provider of a necessary service, Evergy Missouri West should be made whole for the prudent costs that it incurred. But is it really fair for Evergy Missouri West to profit off of this terrible situation? Of course not. Should Evergy Missouri West be held accountable for its choices in the months and years leading up to Storm Uri that further increased its cost during the storm? Absolutely. That's fair. So I'd like to start this morning, or this afternoon, in talking about, in deciding what Evergy Missouri West should fairly recover. The Commission should consider the true cost of Storm Uri. Another way to think of true cost is to determine the amount that someone is actually out of pocket. To illustrate this concept, imagine that you have a $200,000 home. You also have a homeowner's insurance policy. In the horrific event that your home burns down, you're initially out of pocket $200,000, the cost of your home. That's devastating, but a small shred of silver lining exists, the money from your insurance policy. Imagine that amount is $150,000. In that case, the true cost of your home burning down is actually $50,000. $200,000, the amount of your home that you lost, minus the $150,000, the amount of your insurance policy. True cost, the amount of the loss, minus any benefit recovered. To find the true cost of Storm Uri to Evergy Missouri West, the Commission must consider any benefits that Evergy Missouri West received. As OPC's witness, Mr. John Riley, explains, that includes tax benefits. Now, taxes sound a lot more intimidating than my homeowner's insurance analogy, but it's actually very simple. Each of you has a handout entitled True Cost Determination, and for those appearing on the WebEx, I believe it is also showing on the WebEx now. This handout includes 3 scenarios. It's based in a hypothetical simple world. The utility here has a hypothetical $300 million in taxable income. You'll see that at step 1 in each of the 3 scenarios. In 2 of the scenarios, a hypothetical extreme event happens that costs the utility $260 million. In the hypothetical world where this utility operates, the applicable corporate tax rate is 25%. So let's walk through each of the scenarios to find the true cost. We'll begin in the left-hand column, scenario 1. In this scenario, no extreme event occurs. So when it comes tax time, at row 1, we see the utility's $300 million in taxable income. We can skip steps 2 and 3 because no costs associated with an extreme event exist. So we'll move down to step 4, and we'll see again the $300 million in taxable income. There's been no change to that. To determine how much the utility needs to pay in taxes, we simply apply our corporate tax rate, and we see that the utility needs to pay $75 million in taxes. Because there's been no extreme event, there's no true cost. Fairness dictates that the utility recovers nothing more. Moving on to scenario 2, the middle table, you'll see that there's been an extreme event. In this case, the utility chooses to recover its costs through its fuel adjustment clause, or its FAC. Again, we'll start with step 1, $300 million. However, at step 2, we'll include the cost that the utility suffered due to the extreme event, which is $260 million. Moving to step 3, we see that the utility has been made whole for the costs it incurred through recovery in its FAC. And we see the $260 million in taxable income. So here, steps 2 and 3 have canceled each other out. And again, step 4 shows the same $300 million in taxable income. So again, we'll see that the utility needs to pay $75 million in taxes. Here, the true cost of the extreme event has been fully recovered. The utility has been made whole for the costs it incurred through recovery in its FAC. In fairness, it needs to recover nothing more. Finally, let's turn to scenario 3 that appears on the right-hand, in the right-hand table. This is what brings us here today, securitization. In this case, the utility has incurred costs because of an extreme event. However, in this case, it has chosen to securitize those costs. So let's work through the same calculations we've done for scenarios 1 and 2 to see the true cost of the extreme event in this circumstance. Again, we'll start at step 1 and we see the same amount of taxable income. At step 2, we see that the utility has incurred $260 million in costs due to the extreme event. At step 3, though, we see $0. This is different than scenario 2, and that is because the proceeds the utility received from the securitized bonds are received tax-free. Mr. Riley, a CPA with extensive experience in utility regulation, refers to this as a tax-free transaction. Moving to step 4, we see the great impact of this tax-free transaction. The utility's total taxable income has dropped to just $40 million. That is $260 million less than the prior 2 scenarios. The impact of this tax-free transaction continues when we see the amount the utility must pay in taxes. With recovery through securitization, that amount is down to just $10 million. But we're still not done. We have to find the true cost of the extreme event under securitization. Ultimately, what is fair for the utility to recover? To find that, we need 2 more steps, and you'll see those at the bottom of the handout below the tables. First, we need to look at the difference in tax liability. With recovery through the FAC, the utility paid $75 million in taxes, the same amount it paid as if no extreme event occurred. The difference between recovery through the FAC and recovery through securitization is $65 million. Recovery through securitization saved the utility $65 million in taxes. This is just one of the benefits of securitization. But again, what are the true costs of the extreme event? The utility still incurred $260 million in costs due to the extreme event, but that's not the true cost here. To find that, we need to recognize the tax savings by removing them from the costs the utility incurred, just like we did in the home burning example. So there at the bottom of the handout, circled in red, is the true cost, $195 million. That is what the utility is out of pocket for the extreme event. That is the amount it should be allowed to securitize. That is what is fair for the utility to recover before recognizing any other disallowances. Allowing the utility to recover any more would simply allow it to profit off of a terrible situation. It would defeat the benefit of tax savings associated with securitization. Next, I want to talk a little bit about accountability. It's certainly hard to talk about fairness without talking about accountability. Choices have consequences, and those consequences have to be dealt with. Commission, in the world of utility regulation, you are the ones who determine the consequences. 2 utilities, 1 storm, 2 very different consequences. I've handed you another handout entitled Accountability, and for those on the WebEx, you should see it now. And I'd ask everyone else in the room to turn to that as well. Let's talk about Evergy Missouri West and its sister company, Evergy Metro. These companies share the same management. They both suffered the brunt of Storm Uri. However, a gap, or more of a chasm, of over $350 million separates these 2 companies, and you'll see that here on the handout. Evergy Missouri West claims over $295 million in costs related to Storm Uri. Evergy Metro, on the other hand, made enough to not only cover its load and to pay its fuel cost. It also generated an additional $58.2 million in revenue. Again, 2 utilities, 1 storm, 2 very different consequences. How is this possible? Something must have gone wrong. Fairness says that someone must be held accountable for the problems that caused this chasm. As described in Mr. John Robinette's testimony, for at least the last 4 years, the OPC has been detailing the problems with Evergy Missouri West's resource plan. Ms. Lena Mantle, an engineer with over 30 years of experience, and one of the original authors of the Commission's resource planning rules, expands on those problems in this case. It was not only the extreme circumstances of Storm Uri that caused Evergy Missouri West costs, and again, the OPC is not saying that Storm Uri was not an extreme event, but it was also Evergy Missouri West's choices in the years and months leading up to the storm that played a part as well. The Commission has to act. It has to hold Evergy Missouri West accountable for its choices. In fairness to Evergy Missouri West ratepayers, the Commission should recognize the consequences of the company's choices when deciding the amount that Evergy Missouri West can securitize. If not now, when? For my last point, I'd again like to bring us back to undue profits. Again, what is fair for Evergy Missouri West to recover? So let's talk a little bit about the rate to calculate carrying costs. Again, it helps to think about a simple example here. Imagine that you need money for a new car. A bank tells you that they will loan you the money with a 2% interest rate. You agree and buy the car. Life is good. You have a new car. Everything is great. Then when you go to pay the money back, the bank demands payment with the use of a 5% interest rate. You're shocked. That's not fair. The agreement was 2%. Mr. Dave Murray, a CFA with years of experience before the Commission, describes how that is exactly the situation here. I have also handed you a copy of a handout entitled Undue Profits. Again, for those on the WebEx, you should see it now, and I'd ask that everyone in the room turn to that handout now. As Mr. Murray testifies, Evergy Missouri West admits that it uses short-term debt to fund at least part of the Storm Uri costs. However, Evergy Missouri West and staff, as a result of the stipulation, now ask that the Commission to calculate carrying costs using the higher long-term debt rate. Again, where is the fairness in this? What happens to the extra interest money? The answer, that money goes right back to Evergy Missouri West shareholders as undue profits. That simply is not fair. I'd like to conclude this afternoon how I started by reminding the Commission that the OPC is simply asking for what is fair. It is not asking the Commission to deny securitization, nor is the OPC disputing that Storm Uri was extraordinary. Rather, the OPC only asks that the Commission hold Evergy Missouri West accountable for its choices and not allow it to profit off of a terrible situation. I encourage you to ask the OPC's experts questions throughout this week, and I am also available for any questions that you may have at this time. Are there any questions for me?
Any questions from commissioners? I don't have any questions at this time either.
All right, thank you.
Thank you. Well, we have no further opening statements at this time. It's now 3:10. I had indicated I think I'd like some more time, given that this stipulation was just filed. I think a lot of people would like to take a look at it before I release any witnesses from having to appear. So I think we'll just recess for the day at this point and pick up tomorrow with the first witnesses at 9 a.m. in the morning. Is there anything before I adjourn this proceeding for the day that the commission needs to take up? Okay, I heard nothing. We will go off the record, and I will see you all at 9 a.m. tomorrow.